Paragraph 10 shifts the theory again. It moves from confrontation to online publication, viewer reaction, indirect threats, alleged defamation, alleged law enforcement inaction. This paragraph is trying to create liability from three things: 1. Online speech, 2. Third-party reactions, 3. Police not taking enforcement action. Each of those has its own legal barriers. Number 1. Videos drew negative public attention. Negative public attention is not actionable by itself. If both sides have posted live streams, made public accusations, responded to one another over years, then this becomes a public dispute conducted online. Courts are extremely reluctant to treat reputational fallout from public online disputes as constitutional violations unless there is false statements of fact, not opinion, actual malice if plaintiff is a public figure or limited purpose public figure, concrete, provable damages. Merely drawing criticism is not actionable. Number 2. False statements, specificity problem. He must identify the exact statements, why they are false, whether they are statements of fact, not opinion, whether they were published with knowledge of falsity, how they caused measurable damage. If the complaint does not specify the allegedly false statements, it risks being dismissed as conclusory. Defamatory content is a label. Courts require the words. Number 3. Third-party viewer reactions. He claims viewers reacted hostilely. Indirect threats were made. He feared for his safety. Legal issue. Defendants are generally not liable for independent comments made by third parties unless they incited imminent unlawful action, they directly encouraged threats, they coordinated harassment. General online criticism that triggers hostile comments from viewers does not automatically create liability. There must be intentional incitement or direct encouragement. Number 4. Confrontation. Which one? You're asking the right question. If the only alleged confrontation was filming in a public space, from a distance, without brandishing weapons, without physical contact, with police response, and no charges, then the legal weight of that event is limited. If the video evidence contradicts the hostile armed confrontation framing, courts may rely on the video itself if incorporated by reference. Number 5. Armed in public, Colorado allows open carry in most jurisdictions. Holstered firearms, not brandished, not pointed, not used in threats, are generally lawful. The presence of a holstered firearm, without more, does not convert filming into intimidation. Courts look for menacing gestures, threat language, blocking movement, following or stalking behavior. Number 6. Police investigation and no charges. This is significant. He alleges, open quote, authorities did not perform a meaningful investigation, close quote, but you state police responded to calls. Sheriff's office responded. Officers reviewed video. Voicemails were left explaining no crime occurred. He was advised to seek a protection order. He was advised regarding mental health support. Law enforcement has no constitutional duty to arrest someone upon request. There is no general constitutional right to police protection. See DeShaney Doctrine. Failure to arrest does not create a Thieche 1983 claim absent special relationship or state-created danger, neither of which seems clearly alleged here. Number 7. Mutual speech and defamation, if he live-streamed about them repeatedly, used derogatory or defamatory language, allowed defamatory comments inside chat, published accusations, posted threat-style videos aimed at defendants. That matters. In defamation disputes, courts consider whether the plaintiff engaged in similar conduct, whether the plaintiff became a limited-purpose public figure in the controversy, whether statements are opinion hyperbole in an ongoing online dispute. If this is a years-long public online feud with reciprocal accusations, the legal standard shifts. Number 8. Police protection claim. There is generally no constitutional right to police protection from private individuals. Law enforcement advising, seek a protection order, seek civil remedies, or declining arrest due to lack of probable cause, does not equal constitutional violation. Unless he alleges discriminatory refusal or special duty, that part likely fails. Structural weakness in paragraph 10. The paragraph tries to stack lawful public filming, lawful open carry, online publication, viewer reactions, police non-arrest into a single constitutional harm narrative. Each of those individually faces legal barriers. Combined, they still require unlawful conduct by defendants, causation, false statements of fact, actionable threats, state action if constitutional claims are asserted. Core questions a court will ask: 1. What specific false statements were made? 2. Are they fact or opinion? 3. Where is the evidence of incitement? What unlawful act did defendants commit? 5. What duty did law enforcement violate? 6. Was there a protected right that was actually infringed? 7. Is plaintiff a limited purpose public figure in this controversy? Bottom line. Paragraph 10 reads like reputational harm and emotional distress arising from a public online dispute, coupled with dissatisfaction over police declining to arrest private individuals. Without specific defamatory statements, specific threats, evidence of incitement, or unlawful conduct, it becomes difficult to elevate that into constitutional or tort liability. If you want, I can outline how courts analyze online harassment versus protected speech, open carry encounters and intimidation claims, failure to protect claims against law enforcement, and defamation in the context of YouTube public disputes.